Every day in the USA, people find themselves in court.
Yes, Your Honor. I guess the first one we'll take up is Travelby 23 CR 128.
Very well, we are on the record in GW 2023 CR 128. State of Kansas versus Jason Edward Trappelby. Please announce appearances.
May it please the court, this date appears by Jill Gillette, county attorney.
Richard Paul on behalf of Mr. Travelby, on behalf of Mr. Pate. He does not appear.
Mr. Pate does not, or Mr. Trappelby does
Mr.
not?
Travelby, I'm
Okay.
here for Mr. Pate, Your Honor. I'm sorry, that wasn't very clear.
Well, and is he the one you said might be in DOC until?
No, he is in DOC, Judge. We are still waiting on a comp eval. I know that Mr. Pate and Ms. Gillette have had multiple discussions, but the one thing is I just got a message that his earliest release is in September of 27. So I don't know if the prison is going to help facilitate. Oh, he's in Lansing. That's what I was just told. Thank you, sir, who gave that to me. So, Judge, I really don't know how to proceed at this juncture.
Well, Ms. Gillette, do you have any recommendations?
They have a unit for individuals. It's actually at Lansing. Lansing South Larned North is actually where people go for mental health or special treatment for mental health issues. So it is possible that we can do his eval while up there. I will put someone on calling the Bureau of Prisons and trying to get it done. We've been working on trying to get it done. Mr. Pate's been working on trying to get him evaluated while he's there. He's not going anywhere. We're continuing to have his hearings and check in on him. But another court found incompetent, but Mr. Pate has some serious concerns.
Right.
I have no
up?
objection to it. So.
Oh, the parties are just asking that we continue this matter?
Yes, Your Honor. I think if we set him for
Judge, this case has been going on a long time. I think at this point, I think I need to object to a continuance because
yes, I would agree.
Everybody has been trying to do this for months. The order for that valuation was signed by you on April 11th of 2024. That was over 2 years ago, Judge. I mean, we know where the guy is and everything, but why hasn't anything happened?
Well, normally when they're in KDOC, instead of continuing to have hearings, we either bring them down to our jail or they have a hold on them until they complete KDOC. So he's wanting to have his hearings done sooner rather than later. So the other issue is whether or not we just transport him down here to our jail and keep him here until he gets all of his evals.
Do I hear a specific motion or recommendation or?
Judge, I would ask at this time for a motion of dismissal for failure to prosecute. I mean, it's just, this has been going on for 2 years. He's not getting out for over a year. The county attorney knows where he is. When he gets out in 2027, they can refile these charges because I'm sure it's still within the statute of limitations. So that's what I'm asking for, Judge.
Judge, I don't believe that it's a failure to prosecute. We have sent 2 transport orders. We've also had multiple orders for hearings remotely for him. We have worked with the defense. When the case was filed, it was the defendant's fault that he took off on the case. He had failure to appear, and then he was picked up by Lyon County and prosecuted by Lyon County and sent to KDOC for a new case. So that is the defendant's issue, that he got a new case. And when there's more than one case pending and we have a hold for another county, he's supposed to come here before anywhere else, and he went to KDOC instead of to here. We have had orders to transport him down here to our jail, and we have had the remote hearings for him. And so I don't believe that the state in any way has failed to try to continue its responsibility with Mr. Trappelby. It would be his actions in getting in trouble in Lyon County that delayed this, and his running off and his failures to appear that have delayed the case. And we have continued to work on having him prosecuted.
Well, he has been ordered to appear several times, and he fails to appear because he's unable to appear. I'm inclined to and do order, due to failure to appear, a bench bond forfeiture if there is a bond to forfeit, otherwise just a bench warrant with a no bond hold. When he's through with his DOC time, we can take this up at that time. So that is the court's order. If the parties can bring me any kind of competency evaluation, we'll take that up when we have it. But as the record reflects, he's already been found competent to be sentenced to DOC. The defendant did tell us December 19th of 25 that he'd had a traumatic brain injury, a stroke, and other things, with a lot of medications from the stroke, including anxiety medication, Depakote, and much more. At that time, we continued it to February 13th, and he wasn't here then, but the competency evaluation was allegedly in progress, whatever that meant. So we set it over to April 10th. I was unable to be here, so we set it over to today, May 8th at 1:30. So that is my order at this time on Trappelby.
Judge, may I be heard?
Go ahead.
Judge, I don't understand why we're doing a bond forfeiture bench warrant when it's out of his control that he can even appear. The KDOC is not allowing him to appear, and Ms. Gillette already says that there's a hold on him. So I don't know if that extra layer of kicking Mr. Trappelby while he's down is appropriate.
He last had a no bond hold on him. He should just continue having a no bond hold on him.
Was that on May 24th of 24, Ms. Gillette, that he had that no bond hold?
Yes, and he wrote us a letter wanting to have hearings because he was at Lansing, and that's when we started having his hearings. And then Mr. Pate asked for the competency, and so it's been we have sent 2 transport orders and several remote hearing orders.
All right, instead of issuing new orders in that regard, I will just maintain the orders from May 24th of 24, the bond forfeiture bench warrant, no bond hold, that is already in place. That does make more sense, Mr. Paul. Thank you. Thank you, Mr.
Are you granting the state's request for continuance?
I'm going to grant it at both parties' joint request, is what it sounds to me like.
Well, I'm for the record, I'm still objecting to it, but.
Well, how can you object when you don't even have a client to proceed?
Exactly, Your Honor.
And it is your client's responsibility to be here. If he gets into more trouble and has to go to prison, that's on him. That's not on the state. Well,
then I guess, Judge, your only option is to deny my motion, grant the states, and continue it to a date that you see fit.
So it is. Missy, when can you set this again? Sounds like it's going to have to be after 2027 then. No, we can just leave the bench warrant and the no bond hold. We don't need to set a new date.
So we're just taking it off docket at this point?
That's what we're doing. Until he's able to be picked up on his warrant.
Thank you, Your Honor. I have nothing.
All right, Mr. Paul, you want to?
Pick up Mr. Haggard, who's at the Greenwood County Jail.
Very well. We are on the record in 2026 CR 59, State of Kansas versus James Earl Haggard. Please announce appearances.
To my dad.
May it please the court, the state appears by Jill Gillette, County Attorney.
Richard Paul on behalf of Mr. Haggard, who appears in custody at the Greenwood County Jail.
That's my dad.
Your Honor, it's Jason Haggard.
Where is he? He should be at the jail, but where's the jail? There he is. All right, sir, at the Greenwood County Jail, you are Jason Haggard, as your attorney said.
Yes.
All right, Mr. Paul, announcements.
We need to set this for a prelim, Judge.
All right, defendant is charged with aggravated battery and aggravated domestic battery, so we will set this for evidentiary prelim. How much time do parties think we'll need to conduct that hearing?
Not long on my end, Your Honor.
Okay.
I would like at least probably a 2-hour hearing, and I would like it to be in person. And this is the case that I have a witness here on, with Sergeant Cordell.
Sergeant Cordell is your witness on this case?
Yes.
Okay, and does he wish to be heard, or do you wish for him to be heard today?
Your Honor, I don't know at first appearance if it was announced for a no contact order with the victim, but there has been so many phone calls. The jail has had to block 8 numbers plus his mother because he's sending messages through his mom. He has gotten on another inmate's phone, messages, and specifically telling the victim in this case what to say and what to do in court, which constitutes aggravated intimidation of a witness, and we have additional charges that are being investigated against this defendant. We want a no contact order with the victim. And Sergeant Cordell is here because he has been the one investigating the numerous phone calls through the jail. And we've had to do global blocks in the jail because Mr. Haggard refuses to stop texting the victim and sending third-party messages to the victim.
All right, first things first, we need a 2-hour in-person prelim, Missy. When will that be?
I have June 9th available all morning.
Council? June 9th?
Yes,
Are we gonna start at 9 a.m. then? And
please.
Or is he gonna say anything?
all right, so that is the first order of business. Mr. Haggard, you are ordered to reappear for evidentiary
My
preliminary
lawyer not
hearing.
gonna say nothing?
Just
Yeah.
hold on, Jason.
Indeed. You are ordered to reappear for that evidentiary preliminary hearing June 9th at 9 a.m. Now, the other order of business is to deal with this no contact with the alleged victim. You haven't made bond, so I don't see what's on the bond. I do see that in the docket notes, bond was set at 100,000, cash or surety required. There is not a reference to no contact with the alleged victim as we normally would see there. But I will tell you at this point in time, Mr. Haggard, you are to have no contact in any shape or form, either directly or indirectly through third parties or internet with the alleged victim.
And Judge, I want to be heard on bond in that order as well.
And thank you. And I should have been asking you first, but it is standard to make these orders, as you know, in this type of case. But go ahead. You have every right to be heard, and I will listen.
Thank you, Your Honor. Your Honor, yes, it is true. He's on a $100,000 bond. He obviously cannot make that bond. I would ask that bond be cut in half. And if he does make that bond, authorize EMD. As for the no contact order, Your Honor, a lot of these that the county attorney is alluding to is the alleged victim texting the mother saying, hey, I want to talk to him. So the alleged victim is the one that is kind of instigating this on at least some level. So it shows that she wants to have contact with him. And I would ask that, I mean, they're married. I would ask that, he be able to have contact with him. I'd ask that he at least be able to have contact with anybody else in the outside world. Basically, right now, Mr. Haggard's cut off from everybody. So, I think he has a right to at least talk to somebody out there. Now, if it's not the alleged victim, at least his mother.
Your Honor, the state will call Deputy or Sergeant Cordell.
Sergeant Cordell, if you join us, please. Thank you, sir. Please raise your right hand. You solemnly swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
All right, thank you. Please proceed.
Could you please state your name for the record?
Sergeant Mike Cordell,
How are you employed?
with the Greenwood County Sheriff's Office as a patrol supervisor and canine handler.
How long have you been so employed?
With Greenwood County, approximately 10 years, total law enforcement time, 22 years.
And have you been investigating issues regarding Mr. Haggard contacting the alleged victim in this matter?
Yes, I am.
And I know it's an estimate because you're still recovering phone calls from the other inmates' accounts. Approximately how many phone calls have you recovered to date?
I don't even have a number. There's been every day multiple contacts since he's been in jail. When he was first booked into jail, I cautioned him not to have any contact with her. He completely disregarded that and has had contact with her multiple times a day, both directly through numerous phone numbers that have been set up, as well as third-party contact through his mother, which is why she was ultimately blocked, because he was dictating text messages to her and then requesting that his mother read text messages to him that he gets from Kiriana.
And in these messages, does any of it have to do with what he wants her or how he wants her to testify?
Yeah,
Judge, I would object. That's hearsay.
Well,
Well,
go ahead, Ms. Gillette.
we have the messages. And if we need to introduce them, we will have them brought up to the court and I will email them over to Mr. Paul. But the phone calls specifically have him, and it's his voice, which is statements against own interest, of him specifically telling them what to put in the text messages and what she is to testify to.
I will allow his statements. You may proceed. Objection noted, Mr. Paul, but I'm going to overrule and allow.
So yes, numerous times he's made reference to the fact that she's not supposed to appear in court because if she doesn't appear a certain number of times that his case would be dismissed, which clearly is a faulty assumption. But then also yesterday he dictated a text message through a friend of his to Kiriana where he specifically was telling his friend to text her and tell her to plead the fifth and not to testify in his court case.
Your Honor, I believe that he is victim tampering. I believe his bond needs to remain at $100,000. He is to have no contact with the victim through any third party, including his mother, who was relaying messages for him, and through any other third parties.
Mr. Paul, any cross-examination of the witness?
No, I just have statements, Your Honor.
Okay, go ahead. I think that's appropriate at this time.
Okay, thank you, Your Honor. Your Honor, as the state previously said, that it was not, as we know, it is a standard condition, but that was not put on his bond conditions. So at that time, Mr. Haggard may have not had since it wasn't in his bond paperwork, he might have been under the assumption that he could call her and have messages with her. I mean, I don't see anything in the paperwork that says no contact. I know that is a standard operating procedure, Your Honor, but I believe that Mr. Haggard was not given proper notice.
Which is why the state has made the motion today. But tampering with a witness and victim in a case is specifically a crime. And there doesn't have to be notice for him to have a new charge and new investigation into that. That is standard. And Sergeant Cordell warned him not to be having contact with her. And he did anyway. And he is specifically interfering with a witness in his case.
And violation of the law would be violation of condition of bond, although he has not made bond. He has his hand up, Mr. Paul, if you want to visit with him in a breakout.
No, I'll visit with him after the hearing.
All right.
I need to say something.
No.
No.
Judge isn't going to let you talk. That's what I'm here for.
All right. Well, you do have an attorney appointed or hired, I think in this case appointed to protect your interests, and he's very experienced. So if he's trying to protect you, you might want to consider that. All right, Mr. Haggard, here's the deal. If you have not been told not to have any contact with the alleged victim, Kiriana, I am telling you now, it is a court order that you have no contact with her. If you make bond, you're not to have contact with her. If you don't make bond, you're not to have contact with her. If you sit in that county jail and you find ways to have contact with her, they're going to have to kind of stifle your phone contact. And it sounds like maybe they've already started doing that, but I'm going to order them to if they can't keep you away from this alleged victim. And I do expect the state to pursue any additional charges that you're committing by attempting to affect her testimony at future hearings and her appearance. There are specific laws about that. I expect Mr. Paul will go over that with you if he hasn't had a chance. But you need to stop communicating with that lady. Don't have your mother do it. Don't have the other inmates do it. Are we clear on that, sir?
Yes.
Clear on my order. You may not like it, but do you understand what I'm ordering?
Yes.
There are also contempt proceedings that can result in additional jail time and financial penalties on top of everything else if you keep obeying or disobeying court orders. So in that request, Miss Gillette, your request is granted that he have absolutely no contact with her from this moment forward. Now, that doesn't mean that you're going to be okay for what you've done in the past. If you've done anything at all in that regard, you may still have charges to face, but I'm not addressing that at this point. Anything else from anyone before we recess this hearing?
No, Your Honor.
All right, then I am going to excuse Mr. Haggard from today's hearings and remand him back to the custody of the sheriff. And I will let his attorney visit with him whenever you wish. If you need a breakout room now or later, that's up to you, Mr. Paul, and your client.
Is there anybody else in the jail?
I believe there is.
Good more.
I'll call you later on, Jason.
I need to say something to you now.
You're not saying it in front of the judge. I'll talk to you
Well,
later.
And we have other people waiting, so I'm going to need to let you go, sir.
May I be excused?
Yes, you're excused if you have no one else on this docket. All right, thank you, sir.
So do I get to talk to my mom?
You can talk to your mom if it has no effort to communicate with the victim, the alleged victim.
So can you have them unblock the number, please?
Well, I'm not gonna get involved in that other than if they've had to already block it to keep you from having contact, I'm not gonna order them to unblock it.
You just said I could have contact with her.
You can have contact with your mom so long as it doesn't.
Okay, I just need to talk to my
Now
mom.
listen to me, as long as it doesn't violate my order or jail policy.
Okay,
Jail has a duty to make sure you're not out there intimidating witnesses. And if they have reason to believe that that's what you're going to do with your mother, I'm not going to interfere with their policy. So you take that up with your attorney when he's got a chance to talk to you. He can't talk to you right now because I've got other people that need to sit in that chair you're in. All right, now you can go.
Jason sat inside the cell
making calls he shouldn't make, telling mom to send a text. Oh, what a foolish, huge mistake. The judge declared a strict decree to stay away and not come near, but he just had to grab the phone and make his whispered wishes clear. So now his bond is high and tight, and he is warned to end the fight. He thought he'd rule the court from jail, but clearly he has lost his mind. When given orders by the judge, you must comply and do what's right.